Good evening, Mr. Cwalters.
Hey, who's this?
This is Dan. I'm on my cell phone. That's why I sound different.
Hey, Dan. Hey.
Hey.
How are you?
I'm doing fantastic. How about yourself?
I can't complain. I'm still kicking.
It doesn't do any good if you do complain, so. Let me try and get out of the wind here, bud. All right. I'm outside.
I'm of Eden will be restored 7 times over.
Amen. Amen. Well, I'm off location. In other words, I'm in my home state here with my family all around me. I had a hypothetical situation I had to take care of today, which dealt with a court, and I figured I would call in and give my success story, which is, purely hypothetical. It was as I've spoken about before on the calls, it was a child support modification. Last week there was a withdrawal redeposit filed. The first questions out of the judge's mouth were about the notice of the withdrawal redeposit and what that was regarding. So I told the judge that, I just want this court to understand that I'm withdrawing from the at-law jurisdiction and redepositing into the equity jurisdiction because equity has more of an ability to rule on what is fair, just, and right, whereas the at-law jurisdiction causes a conflict between the two jurisdictions. And the judge was actually a little short with me. He's like, I know that. Okay. He's like, is that all you wanted me to know? Yes, sir. He's like, well, I already know that, and all you have to do is ask me. Okay. Well, Your Honor, all my research before, I've never found where a lower district court actually has an equitable power. He's like, well, I'm sure that if I was to go and talk with the panel of judges the next time we're having a meeting, if I was to ask them if they know that they sit as a court of equity in a divorce case, I'm sure they would all know it. I'm like, okay. Hi, my name is Dan. I'll be here all day. So, the other side was asked to give their opening statement, which was done. I gave my opening statement, which kind of rolled into a bit of a testimony, all hypothetical, of course, sworn in, and then proceeded to present evidence. The other side had none to present. All they had was verbal, which for those of you out there that have not ever done the court case themselves, you got to present the evidence, because just like Dr. Graves, I think his name is, for jurisdictionary, says that, the preponderance of evidence is what's going to help beat. You can't just rely on verbal.
Yeah, the SOIs and support, the NOIs.
Bingo. That was, what was his name?
Graves?
Dr. Cwalters. That's right. Yeah, Dr. Cwalters, NOI-SOI.
Oh, that one. Yeah, okay, yeah.
So, I presented the evidence. There was no objections to any of the evidence presented. I had 3 main points, 3 hypothetical main points, which, yes, ladies and gentlemen, major equity was working off of statutes. But the main argument was the spirit of the statute today. I had one statute that I wanted to be enacted, actually the spirit thereof, I should say. I wanted all of the children, for both parties, common and uncommon, to the prior marriage, recognized, and attorney's fees to be responsible by each party. The judge listened to everything that I had to say and asked the lawyer if he had anything to rebut. Every time I presented a piece of evidence, the lawyer was too busy talking to his client and really didn't care. He's like, whatever, yeah, go ahead, it's admitted, fine. At the end of my statement, I sat down. The lawyer stood up and said, basically, the only argument they really had was whether or not the statute, now keep in mind, he's coming from the letter of the law, not the spirit, the statute, whether or not the statute was actually saying what I implied it to say. Long story short, the lawyer and the judge went back and forth for quite a while, a good 4 or 5 minutes. While you're there in the heat of the moment, it feels like hours. And the lawyer was doing his best to wordsmith, literally, ladies and gentlemen. He was wordsmithing things to try and confuse and throw off. The only thing I can think of was me. Obviously, the judge was keeping right up with him. But at one point in the judge said, "So, Mr. Torgus, if I understand correctly, you think that normal parent time is described by statute?" Well, yes, Your Honor. And I'm thinking to myself, no. Normal parent time is what's fair, just, and right. That's equity. That has nothing to do with the letter of the law and what's written down. The letter of the law is the bare minimum, the strictest, the least amount, the bare minimum least amount, not what is normal. But I didn't say anything. I didn't object. I kept my mouth shut, and I let that judge work. And I'll be darned if he didn't come full circle and say, well, Mr. Torgerson, I don't see anywhere where the statute actually defines that normal parent time, where the statutes actually define normal parent time. Because, keep in mind, the statute was for a reduction in child support for extended parent time. And that's what that's what the judge was trying to get out of the lawyer, was the definition of extended parent time. Lawyer came up empty-handed. He couldn't come up with crap. Guess what my judge came up for me? He came up with a definition out of the statutes of what extended parent time is. And guess whose side it was on? Mine. The judge was working for me and with me. It was completely different than the first time I went before this man.
And what was that about?
That was the original divorce, the original setting of hypothetically, the original setting of the child support.
Which happened prior to you knowing NTT?
Absolutely. That was back in 2007, before NTT was even born.
Okay, yeah.
Sorry, 2009. Oh, September 2009, not 2009, September 2009. NTT wasn't born until November of 2009.
So that was purely illegal the first one then?
Yes, that first one was purely illegal. Absolutely purely illegal. I had zero idea. Now, I was heavily involved in my case because I knew it better than my lawyer did, and I understood that, but I had zero idea of how the court operated. I had no idea that there was rules. I had no idea about trusts. I had zero idea about equity. If you asked me back then about equity, I'd have said, the equity in my house I'm currently buying? Nothing. So, those are all minor successes in NTT all the way up till now. Just the knowledge that I have gained by studying NTT or staying with NTT for the last 4 years is I know enough to be able to go into the courtroom myself. Am I nervous? Hell yeah, I'm nervous. But you know what? Once you study this stuff and you know this stuff and you got Lisa over there drilling it into your head, no, it's not statutes and codes, it's equity, you start to automatically talk that way. You start to use verbiage in the court when you're nervous that you don't realize you even have in your head. And it's all due to this study. It's all due to staying focused. The judge, surprisingly enough, was a little bit irritated that I put in that notice. He's like, I know I sit in the court of equity. Now, was it statutory equity versus ancient? I'm a little confused right now myself. I didn't see that judge actually rule on statute today. He ruled on what was fair, just, and right. He took that lawyer through a circle and brought him back to, he literally said, but in the situation of this family, talking about my ex-wife and our 2 kids, hypothetically, in the situation of this family, I think it is this. That's not statutes and codes. That's conscience. Period. And in fact, at the end of the case, after he ruled everything in my favor, I got the child support reduced. I got the statute, the spirit of the statute, mind you. I'm going to come back to that in a second, so keep that in your minds. The spirit of the statute was ruled in my favor. The attorney's fees was a non-issue, not a big deal. But after that was all said and done, that judge started asking me questions about equity. Where did equity originate from? We went back into England. Well, Your Honor, it originally came from when the king actually gave, essentially gave his conscience over to the chancellors to be able to rule, because the common law courts couldn't give a full justice. Now, did I say it just like that in court? No. Was that what I was thinking and trying to explain? Yeah. Was I nervous as all get out and I couldn't get that to flow out as freely as I could right now? Yeah. But when I said the chancellors, he said chancery. I said, yes. Thank you. He said, you get this from some guy off the internet? And I was like, oh my God, does he know Christian? I was like, no, sir, I got this out of the books. This is what Justice Pomeroy has stated. This is what Justice Story has stated. This is even what's in the Utah statute. Whenever there's a conflict or a variance between the rules of equity and the rules of common law, the rules of equity and the rules of common law, the rules of equity shall prevail. So this is my study. I said, even Mr. Bouvier said this. He's like, okay. So it was a test at the beginning and then an interest at the end. My opinion for this judge has completely changed. This man knows what's going on. He understands. The spirit.
That was family court, though, really. So.
That was family court, yeah. And I found several cases that state, a court or a divorce court. According to Utah law, a divorce court sits as a court in equity. Now, they're all older cases, but that doesn't mean that it doesn't have any power. So the ancient equity maxims are ancient, but it doesn't mean they're without power. So, now the spirit of that statute I was talking about, when that lawyer and the judge, hypothetically, were going round and round, that the judge was trying to get out of the lawyer what his true argument was. He said that, the defendant has not actually petitioned the court to modify the child visitation arrangement and blah, 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 blah. And when I got up there, I was like, no, I don't want to modify the child visitation arrangement. I said, this is where I would object, because this is where the conflict or the variance comes in. The conflict and the variance comes in. He's talking about the letter of the letter of the law. I didn't say it exactly this way, but that's what I was thinking. But I'm talking about the spirit of the law. No, I haven't filed a modification to the child visitation because I don't want the state any more involved in this relationship than it has to be. Mom and I have been able to, hypothetically, to come up with a visitation schedule that works for us, so there's no need to. But the fact of the matter is when I do exercise my extended parent time in the summertime, I'm sending all of the child support to their mother when the child support belongs to the child, which has been founded by the Utah Appeals Court and the Supreme Court. I didn't say it at that time because I'd already made the claim and stated the case site. Now, I did state case sites, but they were equitable in nature. They were talking about equity. Coming back here. When I have these children for 3 months out of the year, it hits me, and I would like to be able to take them to Carlsbad Caverns or go up on the mountain. I'm not looking to line my own pockets here. It's it's in the best interest of the children. And the judge looked at me, this is like the second time I've made this type of spiel. He's like, I understand. Okay. So I was ruling out the spirit. The spirit of the statute was, hey, extended parent time. You should not have to send, $1,000 a month back where they're not at. You should be able to keep half of that and enjoy it with them. Yeah. And at the end of the day, that's what was found to be fair, just, and right. And that's what was ruled on. And I think it rubbed the lawyer a little bit of the wrong way, hypothetically. So there you go.
Okay. Bingo.
Yeah, I would say so. Was it a purely equitable case? I don't know, Kristen. It was definitely at least three-quarters of the way equity, because even though they started talking about statutes, and when the judge finally made the ruling, they said, and Mr.
Well, let's put it this way, say that family court in that particular state functions as equity.
I would say yes. And if you have somebody that is, like me, I'm not tooting my own horn here, but understands and can offend and defend the position and prove it to the judge, I think you got it pretty much in the bag.
That's what I was going to say. If we take that and use that as a model, and if we model the spirit of everything as being equity, and maybe we apply it to different forums, say like your regular state court, then, we may have some different results, as you had the same results in family court in that state.
Right.
So, again, the spirit of the law instead of the law itself.
And the conflict. The conflict. There was one point in time I got up and I hypothetically, I quoted the statute, 6434 or whatever it is. I can't remember right now because I'm celebrating with an adult beverage. But
what you kind of put forth tonight is what, Lisa and I were talking about earlier today, was the conflict. And it was brought out between the two of us that really the conflict is the meaning of the statute, and the meaning of the statute is not in the statute itself. It's in the annotated versions, the explanation of the statute.
Or maybe even your own self-interpretation of the statute.
Well, yeah, the way the statute is interpreted is in the annotated.
Yeah.
The annotated is separate from, and not the same writing as the statute itself that's codified. So you read the literal codification, but if you want to know the meaning of it, what it's really doing, you got to go to the annotated. But the annotated is not codified with the statute. Now that's the conflict. Because if you read the literal statute, it could be interpreted as being one thing under a narrow view, but then if you read the annotated, which is someplace else in another book, it's not codified, but it explains the code. And it has a different meaning. There's where it talks about equity. And that's a conflict. And isn't that what you said the judge understood to be? The spirit of the law?
Yeah, he seemed offended.
He what?
He seemed offended that I put that notice in there that, under Utah law, a court of equity sits as a court of, divorce court sits as a court of equity. And, I had quotes from Pomeroy, I had quotes from Mr. Bouvier in there, and he's like, is that all you wanted me to know, is that I sit as a court of equity in the divorce court? In this setting, yeah.
That's
I'm not going to tell you the whole thing, but...
They probably don't want that to be publicly known.
Either that, or he was acting like he was irritated to test.
Oh, that could be too, yeah.
Yeah, and I came up, And, you know, at the very end, Christian, he's like, so where'd you get this stuff off of? The internet? Some guy off the internet? And I was literally like, oh my God, does he heard of Christian before? I was like, no, it's in the old books. This is what Justice Story has talked about, what Justice Pomeroy has talked about, even Mr. Bouvier. It's in the ancient books. And he was like, all right. He's like, all right. And Christian, he was talking to me like you and I talk to each other right now. I was flabbergasted. It was amazing. And he ruled completely in my favor. Equity follows the law. And that's what happened.
Yeah, but equity, its understanding, really departs from the law.
Yeah. Well, you know, I was literally talking in the parable there, so.
If it's not equitable, it departs from the law.
I even at one point in time during the conversation back and forth, I said, you know, he who seeks equity must do equity, and that's according to the golden rule. And he's like, yeah, I remember that. And I said, to be honest with you, Judge, in my opinion, that's the law that's written on your heart when you're born, about the Ten Commandments. He didn't say a word. He went on to talking to the hypothetically went on to talking to the other side's lawyer. So it was very good.
Well, glad to hear that.
Yeah. So there you go, my friend.
There are wins.
Yeah, and it all depends on what your definition of a win is. In my opinion, there was multiple wins today. Not only was I able to go down there and get what I wanted out of the court, but I was able to go down there and get what I wanted out of the court myself. I didn't have to ask the lawyer to help me do it. I did it. It's multiple wins today. A win is not just defined by how much money you get. And that was not my focus today in court. It was what's fair, just, and right for these kids that are involved. And the judge saw that. I guarantee he saw that. He who seeks equity must do equity.
Yep, well, congratulations.
Thank you, Christian.
He's paying off, huh?
Yes. I thank you for everything that you've done for free, selflessly. Thank you.